I'm John Dankosky from the Connecticut Mirror. We're joined by Pulitzer Prize-winning reporter and opinion writer Linda Greenhouse, who's been covering the Supreme Court for the New York Times for many years. She's, of course, a friend of ours and a longtime supporter of the Connecticut Mirror. She's here to answer some of your questions about this most consequential court term. We have at the bottom of the screen, if anything on Zoom works, and I hope it does today, there's a Q&A function that you can ask some questions of Linda Greenhouse. I'll try to get through as many of them as I can. As Linda and I were prepping for this, I think we both realized there's probably more to talk about than we have 1 hour for. And we've already spilled a little bit of time here, so we'll try to get to as many of your questions as possible. I do need to say thanks to our sponsors, the Mohegan Tribe, the Connecticut Business and Industry Association, thanks to Eversource, Clifton Larson Allen, the Causeway Agency, Express Strategies, Hinckley Allen, and Rowthorn Law. Once again, if you want to ask questions, go to the Q&A function. Linda Greenhouse, first of all, how the heck are you? How's your summer so far?
Everything was fine until I couldn't get on the Zoom call.
Okay, well let's dive right in here. I guess the first question that is probably on the minds of an awful lot of people is this the Trump court that so many conservatives have been waiting for and that so many liberals have been dreading for years? I mean, is this the court that was taking shape that we sort of thought it might be when Donald Trump got a chance to make all these appointments to the court during his term?
Well, yes, it's a matter of simple arithmetic, because take away the 3 justices who were appointed by Donald Trump, that is to say, Neil Gorsuch and Brett Kavanaugh and Amy Coney Barrett, we would not have had some of the outcomes that I think most engage and upset people. I'll put a footnote there to Amy Barrett, who, if people have been reading any of the recent commentary about the court, many people have noticed that she is somewhat different than from what many of us expected. She is going her own way in certain key areas. And so, yes, it's the Trump court, but what the Trump court is going to do in the future, we're all going to see together.
Well, let's just go on that thread though for a second. Since you're talking about Coney Barrett, give me some specific examples of where you've seen her maybe not being exactly what people expected her to be.
Well, for instance, look at the immunity case that came down. So the absolute weirdest and really most radical thing that the Chief Justice John Roberts majority opinion did in the immunity case was to say, by the way, at a trial for those actions for which the president is deemed not to be immune, the prosecution cannot bring in any evidence that stems from any of his actions for which he is immune from prosecution. That's a very unusual, unprecedented stance, because, for instance, in an ordinary criminal trial, the prosecution can bring in something called uncharged conduct, where the defendant is not charged with it, is not going to be punished for it if convicted, but the jury can have it in mind in understanding the full sweep of the prosecution's case. Amy Barrett dissented from that part of the majority opinion. Now, it didn't make a difference because they had a majority for it. So that's now the rule. She dissented from an important environmental case that came down late in the term that struck down the Biden administration's effort to regulate the toxic emissions that flow from an industrial state across the state border to another state, and saying that the government didn't have the authority to do that, and she dissented. So, I think she, at her confirmation hearing, she said, if I'm confirmed, you're not going to be getting Justice Scalia, for whom she had clerked. You'll be getting Justice Barrett. So after 4 terms now, we're getting to see interesting outlines of exactly who Justice Barrett is.
Before we get to some more of the important rulings of this term, you had written about a case that the court dismissed and what it might say about how functional this court might actually be. It's this case from Idaho about emergency abortion care. What exactly did you see in the way that the court decided to dismiss this case and allow women in that state, at least temporarily, to get abortion care if their life is at risk?
Yeah, so this was a case, it's a clash between the state of Idaho and the federal government. So the state of Idaho, once the Supreme Court freed it up to do this, has criminalized basically all abortions. There's a federal law that's been on the books for quite a long time. It goes by the shorthand of EMTALA, stands for the long name of the statute, that requires hospitals to provide emergency care, medically necessary care when a patient shows up in the emergency room. So the question here is, abortion's illegal in Idaho. Suppose a woman with a very compromised pregnancy that's threatening her health shows up, and the medically appropriate treatment for this condition is to terminate the pregnancy. What happens? Clash between the Idaho ban and the federal requirement. So the lower court here had basically, it's procedurally complicated, not quite struck down the Idaho law, but issued an injunction against the Idaho law while the whole case played out in the lower courts. The Supreme Court back in January swooped in and granted Idaho's emergency request to lift the injunction, allow the Idaho abortion ban to go back into effect. And the court said, we're going to hear the case, we're going to decide it, even though the lower courts have not finished with the case. Very unusual, very aggressive. So the question was, what's going to happen? The case was argued, fully argued in April. And to everybody's surprise, now about 10 days ago, the court said, well, never mind, we're not going to decide it. And there were a bunch of writing about it. And Justice Alito was very upset, and he wrote a 25-page dissenting opinion from getting rid of the case. Obviously drafted to be the majority opinion, but he couldn't get enough votes. And one of the votes he couldn't get was Amy Barrett's, who herself writes an opinion explaining what happened on behalf of herself and Chief Justice Roberts and Justice Kavanaugh, saying, basically, we made a mistake. We shouldn't have granted the case. We don't know enough about it. It hadn't worked its way through the lower courts. And so we're back to square one. And by the way, the injunction against the Idaho law is back in effect. And so the Idaho ban is not operable at this time. So that was pretty interesting.
It's pretty interesting. What exactly do you think it says about a court that, in the aftermath of it overturning Roe versus Wade, the fact that so many states have, in that aftermath, of course, passed these very restrictive laws, and they're very different state to state. So it makes it very impossible almost for people in certain parts of the country to get abortion services, or sometimes even basic health services for people who can get pregnant. I mean, what do you think it says about the same court that overturned Roe?
Well, so really what was at issue in this case from a 10,000-foot level, you might say, is, okay, what's the aftermath of Dobbs, the decision that overturned Roe? What does it really mean? So Idaho, in its abortion ban, has an exception for the life of the pregnant woman, not for health and not for, the ordinary, well, I guess life, rape and incest, right? So it's kind of how far does the court want to allow the states to go with this newfound freedom that Dobbs gives them to ban abortion? That was really the kind of heart of this case. And what we saw here is that Justice Alito, who wrote Dobbs, very aggressively was, let's just get going. I said they could ban abortion, and let's see them ban abortion. He couldn't get enough followers to follow him off that cliff, and that's why I think this very complicated and kind of hard to follow procedural mess of a case, of a non-case now, why it's so interesting the way it turned out, because the court was on board for granting the case, took 5 votes in this odd posture for the court to grant the case. 5 is a majority of the Supreme Court, but there were not 5 votes to follow Alito for the actual decision on the merits. And it's, could prove to be quite important going forward.
It could prove to be important, and I guess I'm wondering, Linda, if you feel like what this might mean then is with essentially the court throwing it back to the states and saying, make up your own rules. Well, now they've all made up these rules, and as I said, they're convoluted in some cases, cockamamie. They're very, very hard to follow. Sometimes it's very hard to know whether or not you're talking about the life of a mother, the life of a fetus, somebody's health, what rape and incest means. It almost feels as though the court's going to have to grapple with, or at least be asked to grapple with, a lot of questions in the wake of this decision. Now, this might be the first of many of these things it has to consider.
Yes, I think that's right. I mean, this came up in a very particular context, which is a clash between a federal law and a state that says we don't want to follow the federal law. We have a right to ignore the federal law. You don't see that every day, although we're seeing more of it as some of the red state governors are, Texas and Louisiana directly challenging the federal government over immigration and so on. I mean, one thing that was interesting about this case is that during the oral argument back in April, Solicitor General Prelogar for the Biden administration gave a lot of detail about what's actually happening in Idaho. So women who are in crisis pregnancies, wanted pregnancies that cannot continue, can't be treated under that injunction. And about every other week have been airlifted from a hospital in Idaho where they came out of state. And when the Solicitor General was describing the situation, Justice Barrett was obviously very startled to hear that. And as you suggested, John, the court is going to be faced with the consequences on the ground in real time of what happens when a state deprives women of the ability to get basic medical care, part of which is abortion when needed.
I just want to let everyone know we're talking, of course, with Linda Greenhouse, longtime New York Times follower of the Supreme Court, a Pulitzer Prize winner as a reporter, and she's an opinion columnist for the Times right now. She follows the Supreme Court about as closely as anyone. She's, of course, a great friend of the Connecticut Mirror and has done this midsummer classic, I suppose, to me over the course of the last several years, talking about the court. I should say that I'd like to thank our sponsors, the Mohegan Tribe, Connecticut Business and Industry Association, the folks at Eversource, Clifton Larson Allen, the Causeway Agency, Express Strategies, Hinckley Allen, and Rowthorne Law. Those are all folks who have been very supportive of the Connecticut Mirror in this series In the Room. I think, Linda, a lot of people who are here tonight probably want to hear the most about and probably think the most consequential case that the court ruled on was about Trump's immunity from prosecution on charges that he plotted to overturn the 2020 elections. Was it the most consequential ruling of this term in your view?
Oh, yes, I think so. I mean, we never had this question presented before. And the court, was very definitive and very sweeping and, has set a bunch of rules, set an analysis that, speaks to the future. The court said, we're not just deciding a case about Donald Trump, we're deciding a case about the presidency and the rule of law going forward. And it certainly did that. And, we'll be living with the consequences.
But so, of course, we'll be living with the consequences, but we're living with the consequences in large part because we have Donald Trump now running for president once again. And this plays into the ruling, it plays into the calculus of all this. I mean, is it possible that no matter what the court says about this not being about Donald Trump, that it has to only be about Donald Trump because of the very specific set of circumstances that he's facing right now, not just, anything having to do with the 2020 election, but also all of the other charges that he faces, the many charges that he was indicted and found guilty on. This is perhaps a unique case, isn't it?
Well, I think in the court's mind, there's a theory among those who are trying to be generous toward the court that the majority's concern was that if Trump is elected, he will, as he has said, I believe, or certainly suggested, or people speaking for him have said, would indict and prosecute Joe Biden. And under this ruling, that could not happen. So, I'm not quite willing to say it's only about Trump. I think the court did have the presidency writ large in mind. I have no idea what their motivation was. I don't want to ascribe motivation to them. I think they thought they were doing the right thing. And I think those of us who harbored a hope that the court was somehow going to save us from Donald Trump, that was never going to happen. So that's where we are.
There's, of course, another case that directly involved the former president. It was from Colorado, and it was that state's effort to keep him off the ballot because of what it saw as his role in an insurrection in trying to overturn the 2020 election. But that vote was not along party lines. That was a definitive 9-0 vote. Why was that?
Well, I mean, this was a kind of an academic theory that was proposed actually by a couple of law professors kind of late in the day, and that under the Constitution, somebody who I forget the exact wording now, fomented insurrection would not be eligible for public office. I never thought it was going to get anywhere, actually. And I guess 9 justices kind of agreed with that outcome. So it was I don't mean to denigrate many very smart, well-intentioned people who got behind this theory and said this really is, the ticket to ride, but I just never thought it was, actually.
I think, though, it raises probably a lot of questions for people who follow the courts somewhat or are trying to make sense of what the U.S. Supreme Court is doing right now. That in some cases, Linda, it seems as though it's okay for the states to make whatever rules they want. And in some cases, it's not okay for states to make whatever rules they want. And I think that's one of the more flummoxing things for a lot of just Americans who watch this particular court. Is it up to Colorado to say, here's what our election laws are, and we really feel as though we shouldn't have certain people on the ballot for fill in the blank reasons? If that's not states' rights, I don't know what is.
Well, election law is very complicated. But it really comes down to voting. So, if the people of Colorado don't want Donald Trump to be president again, they should not vote for him. And it's not going to be up to the Supreme Court to prevent the votes from taking place. I think that's what that was the court's view there. And, it's fair. It's easy to have broad generalizations and to say, why is it that sometimes the states win and sometimes the states lose? But each case comes up in a very specific context. And, the one thing that separates the justices and that is creating a big debate in the country among people who follow the court is, how do you interpret the Constitution? How do you interpret a statute? And, to what extent do you just go by the plain text, or what extent do you go by context or the purpose behind the statute or the purpose behind the constitutional provision? And those are very fundamental differences in debates that are playing out and that, make the whole situation quite, as you say, quite confounding. And it makes it important to really look at the details of each case to try to figure out what the heck is going on.
So another case that this sort of leads us to, which is, I think, another one of the really consequential cases. I follow climate change issues quite a bit with a lot of my work, and certainly environmental issues. And a lot of people who follow this stuff closely were maybe not surprised at all by the ruling around the Chevron case. It's not the Chevron case, but it's a Chevron ruling that goes back to 1984. That essentially it 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 suggested that courts would defer to agencies, to federal agencies, when they make rules. And the court, by a 6-3 ruling, essentially overturned that. And what it, I think, has the effect of doing, Linda, is really weakening the power of federal agencies. I assume that what the court is saying is, if we want certain rules and laws around the environment or anything else, Congress has to pass those laws, and it can't just be some federal agency making those laws. Am I reading that right? Is that what this change means?
Yeah, I mean, there's a couple of ways to read it. One is that way. Another is that the court has helped itself to a whole bunch of power that when the Chevron case was decided back in 1984, the court essentially gave up. So just to contextualize this, so the holding of the Chevron case back from 1984 is that when a federal agency has issued a rule or adopted a policy that is plausibly within the authority that Congress has given it, judges should defer. And what this new ruling called Loper-Bright said, no, that's an abdication of the judicial function. It's up to Congress to pass the laws, and it's up to the Supreme Court to interpret them, not up to federal bureaucrats to interpret them. So that's, that was that argument. Now I'll say about that, this case, Loper-Bright, the Chevron case, was only one of 3 important administrative law cases that came down this term. And the other 2, you could argue, are actually even more important because the court has disliked Chevron for quite a long time, and in fact has not cited, that is to say, has not relied on Chevron for the last 6 years. And life has gone on, we've adjusted to that. But these 2 other rulings, one that said that an agency, in that case, the Securities and Exchange Commission, has to give a jury trial to the people against whom it's issuing criminal sanctions. It can't just be an administrative tribunal. That's a big deal for the way agencies work. And then another case that was, really very obscure, case called Corner Post, says that anybody who's negatively affected by a rule that was issued even a long time ago by a federal agency, the statute of limitations, the 6-year statute of limitations, runs not from when the agency adopted that rule, which could be a long time ago, but from when you, plaintiff, were first affected by the rule. You could be a brand new company, as in that case. So this is a very destabilizing ruling, because most rules on the books have been there for quite a long time, and the assumption has been people had 6 years to challenge them, the statute of limitations, and once that was over, you could go into court and say, I don't like the way this is applying to me, but you couldn't challenge the basic validity of the rule itself. And now you can, whenever. So,
But what it
in my
sounds like, Linda,
opinion,
yeah. Well, no, go ahead. I was just going to say, what it
I was
sounds
going
like
to
you're
say, I'm
saying, though,
not,
is, yeah. Go ahead. Please go ahead.
I'm not holding myself out as a big expert on administrative law, but it seems to me that those 2 Chevron cases are just as important, although they got much less attention, and could well be more important than the Chevron case itself.
I guess what I was going to say is that it feels in these cases, though, that the court is essentially just giving more power to the courts. It's essentially saying take it up in court, and the court will have more authority. That's sort of the opposite of giving Congress a rulemaking authority. That's saying, you have a lot more ability to change rulings by just taking them to court?
Yeah, I mean, it's a big deal. It's a very big deal. And, watch that space. We'll see how that plays out.
I actually got a question from the Mirror's environmental reporter, Jan Ellen Spiegel. She says on the environmental stuff and Chevron broadly, can Congress really just pass a new, more specific law that would basically harden what now may exist as rulemaking? Or would that new law simply get run through the scaffolding the court put in place and then simply be declared unconstitutional? I think what Jan's essentially asking is has the court set up something that basically makes it impossible for Congress to pass laws that will pass judicial muster when it comes to, the authority of agencies?
Well, I think there's two questions kind of mashed into that. Good question. One is, can Congress? I mean, can Congress, which can hardly do anything these days, as we know, but
Fair.
even a functional Congress that sets up an agency, gives it a broad authority, but cannot in the writing of a statute anticipate all the applications of that authority or, new technology and all those kinds of things. I mean, Congress writes broad, gives broad statutory authority and delegates a good deal to the experts in the agencies. That's number one. The other part of that question is also a very good question. When does a broad delegation run up against this Supreme Court's view of executive branch authority and the separation of powers? And that's a hot button issue. So there are justices on the court, the Trump justices and a couple others, who are really kind of teeing up to bring back in play something called the non-delegation doctrine, which limits Congress in the amount of authority it can just hand to executive branch agencies. And this dates way back to the New Deal period and the fight over federal government authority. And the New Deal this is another big deal. And so, it's entirely possible that we're going to see I would say recrudesce that notion of limitations on Congress's authority to delegate coming up within the next couple of Supreme Court terms.
I suppose this is as good a place to ask this question as any. It was a question that was submitted by one of our members. This is not something that Sam Alito said recently, but it was within the last year. And he wanted to get your thoughts on the statement. I know this is a controversial view, Sam Alito said, but I'm willing to say it. No provision in the Constitution gives them, meaning Congress, the authority to regulate the Supreme Court, period. I'm sure it's something that you've thought about. You've probably written about a little bit. Our member wanted to get a little bit of your insight into what you think exactly that means and what it might signal from Sam Alito.
Well, it's a ridiculous statement because, of course, Congress regulates the federal courts, including the Supreme Court. Article 3 of the Constitution gives Congress a lot of authority to define the jurisdiction of the courts. A lot of the way the Supreme Court operates today is because of things that Congress has done. Congress has given the court authority to pick its own cases. That comes from the 1920s. That's not hardwired into the Constitution. That was a congressional enactment. There are cases in which Congress has taken away the court's authority to decide. In the criminal law area, the Congress has greatly circumscribed the power of the federal courts to hear certain claims from criminal defendants and so on. So that kind of broad brush statement from Alito, I think, is just assuming that his listeners don't know anything, have no history, have no understanding of civics, and it's just flatly wrong.
Another question came in. In all of your years of writing about the court, have you ever been as discouraged as you are today? Is there anything the court is doing that gives you optimism for the future?
Um, well, future's a long time. Uh,
Fair enough.
no, I mean uh, it is discouraging. It's very discouraging. But it's also fascinating. So, I kind of uh, flip back and forth between discouragement and sheer fascination at how things are going to play out. I mean, that's the journalist in me, I guess. My daughter was yelling at me the other day, "Why are you more upset?" I said, "Plenty upset, but I'm also very interested in what's happening, not only in the court, but in our politics."
We got another question from someone who wants to know a little bit more about the difference between the court's opinions regarding immunity with respect to President Nixon and President Trump.
Well, of course, Nixon's resignation meant that the court didn't have to decide the issue that's decided in the Trump case. The Nixon case was about whether he could exercise executive privilege and not turn over the incriminating tape. That's a whole different question. And so, once the court said no executive privilege, the tape was the smoking gun and Nixon resigned. What's interesting about when you hold up the Nixon situation vis-a-vis the Trump situation and the immunity decision is Gerald Ford then, as everybody knows, pardoned Nixon for whatever he may have done, freed him from criminal liability for whatever he may have done. That assumes that he faced liability, right? And nobody at the time said, "Hey, President Ford, you didn't have to do that because after all, the president's immune. So why take the political risk," which many people think cost him the 1976 election, and pardon him? It was just assumed that if the president does something illegal in the White House, he is criminally responsible. In fact, when the Senate declined to convict Donald Trump in the second impeachment trial, Senator Mitch McConnell, then the majority leader, said, "Don't worry about it because he can always be prosecuted in criminal court." So, that's the turn we're at now. The assumption in the Nixon era that, of course, president, if you catch him, can be prosecuted and convicted. That seems to be no longer true.
Yeah, There's a lot of things about the world that's different from back then. But I suppose we'll stick to the parts that deal with the court. Before we run out of time, Linda, I want to ask you about a couple of rulings. And you'd written about the court, in your words, stepping back from the edge in a case involving the gun rights of domestic abusers. This was an 8-1 ruling. What do you think that this case said about the court?
Well, so this case called Rahimi raised the question of whether a federal law that deprives somebody who's under a court order for domestic violence deprives that individual of the right to have a gun. And the question was, does that law violate the Second Amendment? So this was the first follow-on from a case from a couple of years ago called Bruin, which basically upended a whole set of assumptions about the Second Amendment and how it applies, and basically said to courts, if you cannot find, if you're asked to apply the Second Amendment to a gun regulation, if you cannot find the exact same regulation or a very close analog to that regulation back in the 18th century when the Second Amendment was adopted, that regulation is unconstitutional. So back in the 18th century, there were no regulations about people under domestic violence orders not being able to own guns because the whole concept of domestic violence did not really exist. That is to say, husband and wife violence or household violence did not really exist in the 18th century. So this case really put the court to the test. What do they mean in the Bruin case, and how far are they willing to go from the analysis that Justice Clarence Thomas applied in that majority opinion? Turns out they were not willing to go quite that far. So 8-1, leaving Clarence Thomas as the only dissenter, saying what I wrote in Bruin applies here, and this law is unconstitutional. Nobody else agreed to him, agreed with him. Nobody else wanted to go there. And that's really important.
There was another gun case that did follow along ideological lines. It had to do with bump stocks. These are the devices that allow semi-automatic guns to work kind of like machine guns. This one certainly, I think, confused a lot of people. It was passed originally during the Trump administration. Of course, this was in the wake of a terrible shooting in Las Vegas in which a bump stock was used to help kill dozens of people. Linda, Congress has outlawed certain types of weapons before. Why not this particular type of weapon attachment? What exactly was the court trying to get to here?
Well, this was not a constitutional case. This was a matter of statutory interpretation. And the question was, does the existing federal law that regulates possession of assault weapons apply to this particular, or you might say, technological innovation that turns an ordinary rifle into basically an assault weapon? And the court said, no, that it doesn't fit. Congress could go back and make it fit. It was a statutory case of, not that it was not important, but it wasn't, some foundational interpretation of the Second Amendment. The Second Amendment was not at play in that case.
But before we go, I know we want to get to a couple more things. You've written quite a bit about Chief Justice John Roberts, including what control he has over this court right now. Where do you see the Chief Justice at this point in history?
Well, he's been there for 15 years. Is my math right? He came in 2005. 19 years.
Yeah, so I was going to say it's longer than that.
Gotta trust me on arithmetic. And he remains a work in progress. I think from most people's point of view, this term, when you had the calls for Clarence Thomas to recuse himself from the Trump cases because of the close involvement of his wife in the effort to overturn the election. And then you had, Justice Alito, I think a little further from the center here, flying flags that indicated his great sympathy with the insurrectionists. And the Chief Justice didn't really have anything to say about that. He has no power over those people. That's just a fact. Everybody on the court is separately confirmed and empowered to serve for life, and the Chief Justice really can't do anything about it. But he looked kind of helpless. And what I wrote a couple of weeks ago was, my inquiry was, has he lost the court? Now, it's easy to say that's a silly question when he's written a number of the major majority opinions of this term, including the immunity case. So, it really depends. Evaluating him, I think, depends on which lens you're looking at. Are you looking at somebody who embodies the court to the public, symbolizes the court, is out there, kind of educating people about the court? That's not him. He's very private. He's not looking for a platform. If you look at somebody who, can kind of count the votes where it counts, maybe that is him. So, it's beware. I should be wary of generalizations because I made a few myself over the years.
I think we're all guilty of that sometimes. So maybe you can just look ahead at the course of the cases that the court is expected to take up next. We didn't get any religion cases during this term, but as we've talked about over the course of the last 4 years, as we've done this, Linda, we expect to see more of them coming through the Roberts Court. What do you expect to see happening next, and what are the most consequential cases coming down the pipe?
Well, there's a big culture war case about gender transition care for minors. It's a case from 2 cases combined, actually, from Tennessee and Kentucky, 2 states that have made it illegal for certain, medical interventions for trans minors who want to make a medical transition. And that's a hot button case. And I think it's going to, ignite what's already obviously a smoldering culture war involving the whole trans issue. As you said, they didn't have a religion case this term. There's not one quite yet on the docket, but there are a bunch of states that are trying to set up religious charter schools with public money and this kind of thing. So I think it's only a matter of time before the court gets back into the kind of divisive church-state issues that it's been grappling with and that we've discussed in recent years. The court hasn't taken too many cases yet. In the next term, I think they have, they probably fill their docket into November, but I think they still have a lot of openings, and they'll grant more cases maybe later in the summer. Sometimes they do that, or when they come back on the first Monday in October.
Finally, I guess quite a bit of the political conversation over the course of the last several months, certainly, but last years really has been about the age of the politicians that have vied to lead the country: Joe Biden, Donald Trump. But some of the Supreme Court justices are getting up there too. Do you have an expectation that whoever the next president of the United States is will be appointing one or more members of a court?
I have no idea. I really don't.
And there's no sense given from any of the people who are there that they feel at some point ready to step away from this fray, as we saw others didn't, and then unfortunately as they passed away during one of their terms, they were able to be replaced. This is not something that you've heard from anybody or any court insiders that people might be willing to step away or ready to step away at some point in the next several years.
It would be really presumptuous of me even to guess. I don't have any sources that have ever discussed any of that with me.
What do you find most interesting about this work, Linda?
It's important. It's fascinating. I feel a certain obligation to use whatever knowledge I've gained in all these years in helping people who are interested understand the court and the significance of what it's doing. So it's, it's challenging. And there's a certain, fun in the challenge and obligation also that I feel. I'm happy to, I'm lucky to have a platform to say a few things.
I'm glad you're still up for the challenge, and we really very much appreciate you sharing your knowledge with us and obviously sharing your knowledge on the pages of the New York Times. Linda Greenhouse, thank you once again so much for joining us, and thanks for wading through all the technical difficulties at the start.
Yeah, okay, you take care.
Thanks so much. Linda Greenhouse, of course, from the New York Times, a Pulitzer Prize-winning reporter and opinion columnist about the court. Special thanks to our sponsors for this series: In the Room, the Mohegan Tribe, Connecticut Business and Industry Association, Eversource, Clifton Larson Allen, the Causeway Agency, Express Strategies, Hinckley Allen, and Rowthorne Law. I'd like to thank all the members of the Connecticut Mirror team. The last one of these we did, there was a little bit of disruption at the end of the program. I didn't get to thank all the people who helped to make this thing possible. So let me thank Bruce Putterman, the publisher, and Elizabeth Hamilton, the executive editor, Chris Nilsson, our director of operations, and Claire Dignan, our director of philanthropy, Irene Mackey, our membership manager, Gabby DeBenedictis, the manager of audience engagement, and Brianna Nelson, our events coordinator, who all helped to organize these In the Room events. As I said, once again, you can join us for the next In the Room with Secretary of State Stephanie Thomas. I'll be in the room with her. We're not sure where the room is, though. It'll be on Tuesday, September 10th. It'll be somewhere within Connecticut. I know that for sure. So look for more details to be posted soon on our In the Room events page on the Connecticut Mirror. And while you're there at ctmirror.org, just please feel free to click that donate button and support all of the great work that the Connecticut Mirror does. Thanks so much for sticking with us. Enjoy this blustery and very lovely evening across Connecticut. Thank you. I'm John Dankosky, and we'll talk to you soon.